Happy Friday. It's time for more Road Rules with Rachel. I'm Rachel Maddie with the Umansky Law Firm, and today I want to talk a little bit more about the DMV's administrative authority to suspend driver's licenses. Now, this is a perfect example of what I just had happen in court this morning. I had a client who's charged with a third DUI. It's his third DUI arrest, and one of his prior convictions happened within the last 10 years. Now, what that means is that he could be charged with a third-degree felony. It's called third within 10. And if he's charged with a third-degree felony and he's found guilty, that's a mandatory felony conviction, a mandatory 30 days jail minimum, and a mandatory 10-year license suspension. Now, for this particular client, his biggest concern was jail and the felony conviction. He really didn't mind losing his license for 10 years if it meant that he could avoid the other penalties. So we were able to negotiate a resolution where he pled to misdemeanor DUI, received first-time penalties, no jail, just a misdemeanor on his record, and only a 6-month suspension from the court. But we did have to have that unpleasant conversation in the hallway that if he takes this deal, as great as it sounds in court, the DMV is most likely going to turn around and revoke his license for 10 years. Now, for this man in particular, he didn't really care. He doesn't drive anyway. He's a little bit older. He's not working. So for him to avoid jail and the felony conviction, it was worth giving up his license for 10 years. But for most people, that's not the case. So before you accept any plea offer, make sure you ask your attorney what the DMV is going to do that the court may not impose, because that's extremely important. And for a lot of people, that's the difference between entering a plea or taking your chances at trial. Everyone have a safe and happy weekend, but if you do get pulled over, call Rachel.